Patents date back for hundreds of years. A Venetian statute of 1474 effectively articulated the bargain that the state offers inventors. In return for disclosure of your inventions to the public, the state will provide you with legal protection from infringers for a limited period of time. Almost identical patent protection for inventors was written into the original U.S. Constitution and has been supplemented by many subsequent federal laws and statutes. It's sometimes better not to file a patent. If Coca-Cola had patented its recipe, the recipe would have been disclosed to the public and the patent would have been good for only a 20-year term. So Coca-Cola decided to protect their recipe as a trade secret. Trade secrets have advantages over patents in that they extend indefinitely, beyond the 20-year term of the patent. Trade secrets are not disclosed to the public in the same way that patents are, and they provide protection against theft by through state law. The disadvantage of a trade secret is that it does not provide protection against reverse engineering. So someone else, like Pepsi for example, can create their own version of the recipe, and Coca-Cola has no redress through the legal system to stop them from doing that unless they steal the secret from Coca-Cola. The other option is to file no patents whatsoever. If you're the first inventor, you can get to use the invention. If you maintain it as a trade secret, then if it's subsequently patented, may be patented by someone else in that case, but they will not be able to enforce the patent against you because you were the first inventor. If you don't keep it as a trade secret, then the patent is public domain and no one else is able to patent it because you're the first inventor. The patent must be accompanied by one or more claims. The claim defines really the boundaries of what you can exclude others from doing. You can think of it like the fence line around your property. Each claim is restricted to a single sentence. So patent attorneys often write very, very long single sentences in order to clearly define the claim. The Patent Office charges for each claim and will recommend dividing the application into two or more applications if there are several claims that are unrelated. There's no such thing as a universal patent. Your US patent is only enforceable in the United States. Your French patent is only enforceable in France. So you need a patent for each individual country in which you're planning to sell your patented invention. Under the Paris Convention, which many countries adhere to, once you file a patent in one country, you have 12 months to then file for the same patent in another country, and you can benefit from the original filing date. The Patent Cooperation Treaty is a system that basically streamlines the process of filing patents in many countries at once. However, it doesn't change the basic rule that you only have patent protection in a country in which you have a patent actually approved and issued for that specific country. Patents have a lifetime of 20 years before they go into the public domain. At that point, anyone and everyone can use your patented inventions, just like generic drugs. This is the reason why some people choose not to patent. The US Constitution talks about inventors and gives the patent rights to the inventor, not the inventor's employer. So, unless the invention is assigned to the employer, it will become the personal property of the inventor-employee. Joint inventors may invent very little but own everything. To qualify as a joint inventor, a person need only contribute one element of one claim. They may be involved in the conception of the claim or in the reduction to practice of that claim. However, that joint inventor gets to own the whole patent. It's very similar to joint homeowners. Each homeowner gets to access all the property without having to account to the other homeowner. So a joint inventor actually has ownership of the whole patent and can use and license the whole patent without accounting to the other joint inventor. This means that a potential infringer, if you have an infringer that you're bringing a suit against, that infringer may bring in a joint inventor and actually buy a license from that joint inventor and therefore escape liability in the case. It's important to note that a patent that does not name all joint inventors can also be invalidated by the courts. So it's important to make sure that all joint inventors are actually named on the patent application. Huge manufacturing centers are growing up in China, the Pearl River Delta area in particular, Taiwan, Korea, Japan, and other manufacturing centers in Asia. These manufacturers are looking for patents, particularly US patents, in order to acquire that will allow them the protection to sell products into the United States market. So a lot of patents are being acquired by Asian manufacturing organizations, and they're being migrating over to Asia where the manufacturing base is building products that are going to be shipped into the United States and European markets. A patent is worthless without a strategy. Large corporations generate revenues through building new products and revenue streams from their patented inventions. Research and development labs often out-license their patents to others. Some inventors form startup companies that they take all the way from zero to IPO or actually sell the companies with some profitable exit. Another option, if you have your own in-house legal team, is to enforce the patents directly against others. If you don't have your own team, then you may want to look at enforcing through partnering with an existing legal team. So the patent's value really depends on the IP strategy that is built around it.